Ladies and gentlemen, thank you all for joining us. I do appreciate that many of you are still streaming in here. I'm particularly delighted to be joined by somebody from New York City, and of course it's not a competition by any means, but if anybody out there is further afield than that, we'd be happy to hear. New York is the current record, but anybody in New Zealand or elsewhere would be happy to hear from you. And equally, if you happen to be sitting in your front room a matter of miles away from us, then we extend a warm welcome to you as well. My name is Andrew Sutherland. I'm one of the practice managers at Arnot Manderson Advocates. I'm about to pass you on to Jonathan Brodie QC, who is, as well as one of the senior members of our stable, is the current stable director for Arnot Manderson. And he will in turn introduce Fergus Whyte, whose current status is that of a devil, but we'll be calling I think on the 29th of this month, and will thereafter be available for instruction in relation to all matters, whether it's connected to the subject of his talk today or indeed anything else. Ladies and gentlemen, if I might just say something, this you will understand is something of a new technology for us and most likely for you guys as well. So if I could just ask that in relation to the way we conduct this webinar today, could I suggest that the chat function be used to inform us of any technical issues, or indeed if you want to chip in with how far away you are, which part of the world, by all means. But for technical issues, if we could use the chat function, that would be great. There is intended to be a question and answer session at the end of this, at the end of Fergus's talk. Fergus, I think, will talk around about 40-45 minutes, and then there'll be time for questions afterwards. Can I suggest that you use the question and answer button on your screen to submit any questions? You can submit questions throughout, but because of the format that we're using here, rather than take questions as we go along, I think it might be a bit better to address these questions at the end, and we will try and answer as many of those as we can. If we don't get through every question, I would invite you to email the stable, and we can forward on any questions that you may have for Fergus that perhaps aren't addressed on the day. On the subject of emails, I think after this event has concluded, we will email to you individually any slides that Fergus uses just now, and you will have an opportunity to take those and examine them. So if there are slides that appear in the course of the presentation today that you would like to go back and look at in more detail, then please be assured those will be emailed out to you. And if in fact you miss any of the presentation, whether that be because you're joining us late or young children or pets interrupt you or whatever it happens to be, I'm delighted to say that the stable now has a YouTube channel, and this presentation, together with all the others in the Better the Devil You Know series, will be available just as soon as practical on our YouTube session, so you can see the whole thing in its entirety. You can encourage your colleagues to look at it, and as Jonathan Brodie suggested, if you're fed up of Joe Wicks on YouTube, then you can tune into us at any point you like. So with all of that in mind, I'll pass you on to Jonathan Brodie. I will mute myself and disappear from the scene for a little while, and I'll keep an eye on the chats and the question and answers and be around to facilitate that towards the end of the presentation. Thank you, and on to Jonathan.
Thank you, Andrew, and good afternoon to everybody. It's a very real pleasure for me as Director of Arnot Manderson Advocates to welcome you to the first in this year's series of Better the Devil You Know. This is a program our stable has offered for a number of years and gives an opportunity for newly calling members to present themselves to the profession and for us all to hear what they have to say. Today's event is fully subscribed, and to me that shows that the legal profession in Scotland is adapting quickly to our changed circumstances and the need to rebuild the economy. That must surely be an encouraging sign for us all. Fergus, I am delighted to introduce today's speaker, Fergus Whyte, who will call to the bar at the end of June. He may be new to the Scottish Bar, but he comes as one who is already an established practitioner, and one with an outstanding academic record. His strong academic performance can be seen in the fact that he has a first class honours degree in law from the University of Otago in Dunedin, New Zealand. He has an LLM with distinction from Edinburgh University. There's a neat symmetry from Dunedin to Edinburgh. He did Scots law the hard way because he went through all the faculties exams for the necessary subject. And he is a tutor in contract and European Union law at Edinburgh University. More than that, however, Fergus is already an established practitioner who is called as a barrister and solicitor in New Zealand, both in the superior courts there and in high-value commercial arbitration. The practical application of the law on his part is also well established. He's been a judicial assistant, he's been a researcher to the Edinburgh Tram Inquiry, and he's an associate member of the Chartered Institute of Arbitrators. In addition to all of that, he's outward facing. The fact that he has been in practice in New Zealand is an example of that. And I think further examples are found in him being a fluent French speaker. And according to him, he can get by in Spanish, though others tell me that actually he is pretty well fluent in Spanish. So I think that may be a mark of his usual and typical modesty. The practice in which he has already been established, albeit firth of this jurisdiction, has been in the fields of commercial law, media law, privacy and defamation, property and public law. His fault may be that he's modest, but having witnessed the Devil's training program in which I've been involved, he is both tenacious and effective in case presentation. From practice in New Zealand and arbitration, Fergus already has experience in each of these areas I have mentioned: commercial law, media, privacy, defamation, property, and public law. And with this range of skills, and may I say a very helpful approach in general, the stable sees Fergus as a very real asset to the faculty. To his talk, the subject has already been made known, but access to court documents by non-parties to litigation is the title. And following the decision of the Supreme Court in Cape Intermediate against Dring and the decision of the Inner House in Cheria against the Advocate General, there seem to be a number of questions arising about the right of non-parties to access court documents, what documents they are likely to be able to access, and the procedures for doing so are what Fergus is going to attempt to address in his talk today. And it seems to me that this talk is on a subject that is very topical and of acute interest to all litigants. To what extent might the personal injuries lawyer be able to obtain productions lodged in one case in order to pursue their own employer's liability claim? To what extent might a party to a commercial action have to bear in mind the possibility that the productions they choose to lodge might be seen by a competitor? To what extent in a judicial review may the would-be petitioner be able to benefit from the productions lodged in an existing judicial review? Truly, this is a topic which, whatever particular area of litigation you are normally involved in, truly this is a topic that covers them all. Fergus.
Thank you for that, Jonathan, and welcome everyone to this talk. What I'm going to do now is I'm going to put my slides up on the screen so you can see them, and then you can follow along with me as I go through them. And here we hit our first technical stumble. Andrew, are you able to enable screen sharing for me?
One moment, Fergus. I'm looking at the technical side of it. It seemed to work perfectly well the other day. Of course, needless to say, it's now causing me a difficulty. All panelists ought now to be able to share their screen. So go ahead, please.
Excellent. Let me bring that up. Just to check with you, can you now see that?
I can indeed, yes.
Excellent. If anyone's able to confirm in the chat that they're now able to see, that would be lovely as well.
For what it's worth, Fergus, Jonathan here, I can see it as well.
Okay.
And I see in the chat that we're getting a series of yes. That's good.
Lovely. Okay. So as Jonathan mentioned, my topic is on the question of access to court documents in Scotland by non-parties. And what I want to do is just start off with some introductory notes that frame up this topic. The idea for this topic came from a friend of mine who works for a firm in London, and there was a case in Scotland to do with something they were dealing with, where they thought they might need access to documents in the court session. Ultimately, that didn't go ahead, but my curiosity was piqued, and I naively thought there must be some rule dealt with this or some commentary on this question. But some brief poking around showed that there was very little at all to go on. And that led me to the question, what is the position in Scotland for non-parties seeking to access court documents? And that question became more important and more easy to try and discuss in light of the two decisions that you can see at the bottom of that slide. The first is the decision of the Supreme Court on appeal from the Court of Appeal of England and Wales in Cape Intermediate. And the second is the decision that I think everyone will know about, Cherry and the Advocate General, which was heard by the Inner House. Now, before I get started, I want to put forward, set up some introductory qualifiers. I'm using the term court documents to refer to quite a wide range of materials and using it as a general descriptor, because as we'll see, there can be terminological difficulties with the rules in describing things as court records or a process or things like that. So this is intended to be a general category. And the second qualifier is that I'm dealing mainly here with civil litigation, though many of the questions that come up, I think, are equally applicable to criminal litigation. And I would say in passing, there doesn't seem to be any easy answer to these questions under either the 1995 Act or the 1996 rules. And the last one is we're talking about documents which are still in the custody of a civil court. There are some special rules and some special questions that apply once the court transfers its records to the National Records of Scotland, for instance. So with those things in mind, what I want to do is turn to the classic judicial showstopper, which is the question that you should never want to hear from a judge. Why does this matter? But to which you should always have an answer. I think to my mind, there are 4 reasons, at least, why this question of access to court documents by non-parties matters. And the first is the academic angle. It's research. A legal academic or a social science academic might want access to a court file because it tells them more about what is going on in that case. If anyone's read Lord Rogers' article in Donoghue and Stevenson, his look at the court file tells us much more about that case than we'd ever previously known. The second is a bit more practical. For those of you who are media lawyers or who advise media clients, they may have an interest in reporting in more depth on the details of the case, and that may be either pre or post judgment in that case. And Cherry is a good example of that. And that means that media organization may want to go into the court file and find out what's going on in greater depth. Can they do so? Third is moving to their use in litigation. And this might be seen as using these court documents in litigation in an offensive capacity. And there are a number of different strands to this. Let's say a novel case has been brought, but has somehow, or for some reason, settled before a final judgment has been delivered. Do you want to see how that case was run? Do you want to see what the legal arguments were? And if that provides you with a basis for running your own novel case based on that template? If you don't have a judgment, then being able to see the parties' pleadings and perhaps even their written notes of argument provides you with a starter for doing so. The second is in terms of if you're able to access witness statements or documents or expert reports. Can you show that in related proceedings, a witness has said something different, or an expert has taken different lines, or even that a party has put its case differently to different courts? And what is the effect of that inconsistency, or perhaps even something worse, if a witness has done something they shouldn't have done and said two different things in two different proceedings about the same thing? And the third angle is one that Jonathan touched on, the question of evidence recovery. Are there evidentiary documents that you can try and get from one court process to use in another? That might be purely productions, but it might also be things like transcripts, which give you more information about the document you're looking to look at. And there are potentially interesting applications of this. As most of you will be aware, the test for seeking documents under the Administration of Justice Scotland Act, Section 1, is that you can only get documents from a party if a case is likely to be brought. So that's a reasonably high threshold. Suppose you have a case in which you've not yet met that threshold. Is going to the court file in a related proceeding and seeking access to the documents through that court file an alternative to an administration of justice order? Another thing to think about. The fourth purpose is what might be termed, talking about this in terms of litigation, but in a defensive capacity. In some areas of law, parties will have the option between courts and other forums, and those who advise on both the writing of dispute resolution clauses and where parties have an option whether they should go to arbitration or to court litigation will need to bear in mind the fact that their client might be sensitive to having documents disclosed or accessed by non-parties in the course of court litigation. So that's something to bear in mind both at the inception of contract writing, where a dispute clause has to be agreed on, and at the time when it comes to decide whether parties want to go to court or use some other kind of mechanism. And that also leads into the question, where there is no option but to go to court, are there things you should be thinking about in terms of confidentiality? Is there any capacity for protective orders or steps within the court process that you can take, knowing that people may be able to access these documents? And I'll come back to that a little bit at the end. With those reasons in mind, what I want to do now is turn to outline what happened in Cape Intermediate and what important issues I think it raises. So what's important to understand about this case is just a little bit of the background. So Cape and its related holdings were the manufacturers of asbestos boards. And they were sued by a number of insurers who'd had to pay out in respect of mesothelioma claims. And the insurers sought a contribution from Cape in respect of those, because it was alleged they had failed to warn of asbestos exposure risks from those products. Now, the case had proceeded all the way to trial and had been heard over a number of weeks, and a judgment was pending when the case was actually settled between the insurers and Cape. And that's the point at which there's intervention by a group known as the Asbestos Victim Support Groups Forum UK, which I'm going to refer to the forum for obvious reasons. And Mr. Dring serves as the representative of that group because the group was an unincorporated body. So his name is the one on the judgment. Now, the reason the forum sought access was that the judgment dealt with significant issues around the state of knowledge at the time that these products were on the market, and also dealt with significant issues around inputs into what is known as Technical Data Notice 13. Now, I am not an industrial disease lawyer, but I understand that that is, for some of those in that area, a relatively important piece of history. The application by the forum needs to be looked at against the background of the English procedural rules. Now, I'm not going to go into these in enormous depth, but I think it's important to understand them so as to understand what the courts were saying, and also so as to compare them and contrast them with the position in Scotland, and consider how the position might be developed in Scotland. The relevant rules are found in Part 5 of the Civil Procedure Rules, and those rules apply across the core civil jurisdictions in England and Wales. Now, what these rules set up effectively is two levels of access. The first is under Rule 5.4c, paragraph 1. And under that rule, anyone can get access to documents that are statements of case or judgments or orders of the court. And that can occur at any time in the process of the proceeding, and it can occur without having to ask the permission of the court. So this is referred to in some of the judgments as access as of right. Now, this gives you access to statement of claim documents, which are claim forms and particulars of claim, defenses, and any additional documents that help to clarify or particularize those. So it's a fairly narrow set of core pleadings that you have access to as of right. The second category is covered by, or the second level of access is covered by Rule 5.4c2. And that relates to all other documents. Now here I put the rule up on the slide because the wording of it becomes an important consideration in the judgments. And what it says is that a non-party may, if the court gives permission, obtain from the records of court a copy of any other document filed by a party. I've underlined those two expressions, records of the court and any other document filed, because they raise interesting questions about what is a record of the court and when a document is filed. And those become key issues in the course of the Cape litigation. For instance, is a note of argument that's handed up on the day something that's filed with the court, or is it merely passed to the judge by a counsel on the day? Transcripts raise similar issues. To access this type of document, a party must make an application under a defined procedural track, and the matter is determined by a judge. Now, there's no explicit guidance in the CPR as to how the power under Rule 5.4c2 is to be exercised, but there is a body of case law that attempts to grapple with those issues. The CPR don't apply to family proceedings, and it's also notable that they don't apply to certain types of litigation, such as closed material procedures for national security reasons. There's also one final point to note in relation to these rules, and that is that a party can take a preemptive, protective step. They can seek to have those core pleadings documents, which are available as of right, redacted or subject to control by a judge. And that would normally be something you would expect to see at the outset. If a party files a particulars of claim or defense containing sensitive or commercially confidential material, then they will file an application alongside that to try and protect that document from disclosure as of right. And Cape Intermediate is particularly interesting because it throws this question of what court documents are into quite strong relief. This is a quick case that settles after hearing but prior to judgment. So there's a full range of documents relating to this litigation available. There are pleadings, there are witness statements, there are the accompanying productions or exhibits to those witness statements. There are expert reports, again with productions and exhibits. There are skeleton arguments or written submissions, transcripts of the evidence as it was taken and the hearing as submissions were made to the judge. There are, given the English context, sets of disclosure materials. And this is an unusual case because those disclosure materials were actually present in the court in case the parties needed to refer to them as the course of the evidence evolved. And then there are a whole range of other things, bundles that might be compiled from these prior types of documents and other ad hoc documents that are compiled by parties for the use of the court, such as chronologies, reading lists, things of that nature. And the question is really, what types of documents are you going to get access to from this large set of categories? What the forum had done was obtain access to the documents it was entitled to as of right. And it then made the application to the High Court seeking almost all of these types of documents, including, unusually, the parties' disclosure materials that were available as that electronic set. And so it's this decision, it's this question, what of these documents is the forum entitled access to, that really forms the heart of the CAPE line of cases. As you'll see, CAPE Intermediate goes through a number of different hearings, and there's some drift in the issues involved. There are also very substantial judgments at each stage of this litigation. I'm not going to be able to highlight all of these issues, but I have tried to identify what I think are some of the core ones. The first is the jurisdictional question. Is the CPR a code in the areas where it applies, and therefore the only basis on which you can seek access as a non-party? And that links into the second question. How do you interpret terms within these rules like records and filed? Because that will naturally limit the scope of that jurisdiction. And the third major point worth considering is, what is the test for access? What approach should the court adopt? What criteria should weigh in that approach? How should the court deal with various issues? And that's a major question, and one that could be the subject of an entire presentation in and of itself. So I'm only going to mention a few of the factors that I think are interesting and particular to this litigation. One is the standing or the legitimate interest or the purpose of the applicant. How do we gateway control who is going to be a person who should legitimately be able to seek access to these types of documents? The second one, particularly in CAPE, is, does settlement matter? Does settlement of a proceeding after hearing matter? And that leads into the next one. At what stage of the court process do these document rights become effective, or what levels of access do you get pre and post hearing? And that's a question the court has to grapple with in a number of different cases prior to this one. And there are any number of other questions that need to be taken into account, or the interests of the original parties to litigation, for instance. The last point that really undergirds a lot of what is said in each of the decisions is the question of open justice. And the court puts considerable emphasis on this, how this principle is to be interpreted and how it might shape the approach to the treatment of such applications by non-parties. So, as I said, there are a number of decisions in CAPE Intermediate, all of which raise some quite interesting and substantial issues in themselves. And I can't hope to cover them in any great detail, but what I'm going to try and do is summarize them briefly. And I've got the citations there on the slide for anyone who wants to look at them in greater depth. In the High Court, the matter is decided by Master MacLeod, one of the procedural judges in the Queen's Bench. And she holds that there are two bases of jurisdiction that a person might seek to access these documents under. One is under the CPR rules that we've seen, but the other is under the common law, under the court's inherent jurisdiction to regulate its own procedures. And that will be available perhaps where the common law, where the CPR rules don't cover a document. In terms of the interpretation of the CPR, the master takes quite a wide interpretation, which means that a lot of material is covered by that definition. And the master goes through a number of elements of the test for deciding whether access should be granted. And she finds that the forum does have a legitimate interest because it does seek to understand why asbestos was classified in the way it was, why it was treated in the way it was, and it does seek to provide litigation support to some survivors. And she concludes that where documents have been referred to in open court, the default position is in favor of disclosure, though there will need to be a weighing of any legitimate interests of the parties to the litigation. Other documents which have not been referred to in open court or which have not been the subject of a hearing might be disclosed, but there will need to be a strong interest in doing so. And interestingly, settlement is seen as completely irrelevant to the court's determination. The fact that parties have settled after a hearing does not draw a veil over those proceedings, meaning that a non-party cannot look at them. So the master ultimately grants the forum access to the vast majority of documents it's sought, with the exception of those disclosure sets of documents. And in terms of the open justice principle, I think what the master's decision can be seen as affirming is that the principle of open justice is relevant in a dispute between two private parties, and it extends beyond the right of a non-party merely to be present in court and hear the arguments. That party is entitled to ask for more and to go further and understand the context in which that litigation is occurring, and perhaps ultimately a decision might be made. So that's the High Court's decision. CAPE is not happy with this, and so it seeks to appeal it to the Court of Appeal. And again, I'm going to treat the Court of Appeal's decision fairly briefly, given the time available to me. The Court of Appeal affirms the idea that there are two bases of jurisdiction, both the CPR and the inherent jurisdiction, but it narrows both of them. Its interpretation of the CPR is much narrower than the High Court's. And in terms of the inherent jurisdiction, the court sees a much smaller category of documents as being liable to be disclosed under the inherent jurisdiction. For instance, exhibits to witness statements will very rarely be available on the Court of Appeal's approach. And it also suggests that this concept of disclosing these documents is very much tied to whether a hearing has occurred or not, in a way that's perhaps more rigid than the approach taken by the High Court. The Court of Appeal acknowledges the principle of open justice, but I think overall its approach to this question can be seen as much more conservative and much more focused on the concept of this as a dispute between two private parties that happens to require adjudication. So, with that, the matter appears in the Supreme Court in February of 2019. And this is an appeal by CAPE from the Court of Appeal seeking to further narrow the scope of the disclosure, and with the forum trying to effectively turn back the clock and go back to what the master had said they had, a quite broad range of documents. In terms of the jurisdiction question, CAPE sought to argue that the CPR rules effectively ousted the court's inherent jurisdiction in all but the most exceptional of circumstances. And the Supreme Court rejected that. It held that there was both jurisdiction under the CPR and under the inherent jurisdiction. And in terms of the interpretation of the CPR, the Supreme Court again holds to a relatively narrow reading of the civil procedure rules. But where it differs from the Court of Appeal is that it shows itself more willing to make orders for access by non-parties under the inherent jurisdiction. And this is where matters may get a little bit subjective, because my reading of the Supreme Court's decision is that it is that much more permissive than the Court of Appeals. I think it would allow a wider range of documents to be accessed by non-parties, i.e. it has a much broader concept of what is necessary to understand the proceedings than the Court of Appeal had. It's no longer simply tied to documents being read in open court or being repeated by a witness or being directly quoted from. I think it's a broader conception of what is necessary to understand the course of the proceedings. I also think, and this is a slightly more subtle point, the Supreme Court's decision is more open to the idea that you might be able to access documents in civil proceedings even where a hearing hasn't gone ahead, if there is some compelling reason to do so. And that might be to understand the court's function or to serve the wider interests of the administration of justice. If, for instance, an important piece of litigation has been abandoned, is there something on the court file that tells you why it's been abandoned, and should a non-party be able to access that and understand why that piece of litigation has come to a halt? I think that is more permissive than the Court of Appeals approach, which focuses on the notion of what has happened in a hearing and what you need to understand within the concept of the hearing. On the open justice principle, the Supreme Court's decision puts this front and center. It's very much the preeminent plank of its reasoning. And it makes that the kind of starting point where cases have gone to a hearing. I think overall it might signal a reorientation or a change in attitude. It means that the court is likely to be more willing to entertain these kind of applications, more willing to grant access to a wider range of documents, and more willing to entertain a wider range of non-parties because of its reading of the notion of open justice. Reduced to its simplest, I think the court is saying you should take a more favorable attitude to these applications. And that goes counter to what was decided by the Court of Appeal. There's one other curious feature of the Cape intermediate decision, which I'm going to put up on the slides now. And this is something I've not seen before, but it's a postscript to the judgment. And this says effectively that this decision has a wider impact. And I'll read just very briefly from the first and last sentences there. And what the Supreme Court says is, we would urge the bodies responsible for framing the court rules in each part of the United Kingdom to give consideration to the questions of principle and practice raised by this case. And coming down to the final sentence, this and the other practical questions touched on above are more suitable for resolution through a consultative process in which all interests are represented than through the prism of an individual case. So the court is acknowledging here the preeminence, I think, of the open justice principle and how that might reshape the landscape, or how it changes the direction to a more permissive approach to access to documents. But it's also saying that the issues here are technical and can throw up a lot of practical difficulties and need to be considered by the courts or by civil justice reform bodies in each of the different jurisdictions. Now, that comment is made in July 2019, and it's an interesting one given what happens shortly afterwards in Scotland and the way in which the open justice principle comes to be tested in Cherry in late 2019. Now, what I want to do before I discuss the decision in Cherry is discuss a little bit of the background against which Cherry is operating. And what became apparent when I started looking into this is that the position in Scotland is considerably less clear and appears to have been the subject of only very limited consideration. So for proceedings in the Court of Session, the only rule which appears to have any bearing on the question of non-party access to court documents is Rule 14.11.1. And you can see the text of that on screen. And that says that a writ shall remain in the office of court and shall not be barred from process, but may be inspected by any person having an interest. Now, the definition of writ is set out in the rules, and that effectively applies to core pleadings documents. There might be some ambiguity around what's covered by some of those, but it's summonses, answers, defenses, petitions, things of that nature. The more interesting term is probably persons having an interest, because that term is not defined in the court rules. And that is left open to some degree of doubt. The authors, for instance, of the commentary to the rules of the Court of Session suggest that it might include a person who is going to become a party to the cause, i.e. someone who's likely to be brought in under third-party procedure, or who might be assisted in as in substitution for one of the parties. But the authors of the commentary doesn't think it goes any further than that, and they don't think it provides a general right of access to pleadings for court documents. Sorry, I noticed there's a little comment about my sound, so I'll try and keep it as stable as possible. Turning then to the other major set of civil procedure rules, the ordinary cause rules. Now, these are narrower and more definite than the Court of Session rules. The equivalent rule is Rule 11.3, and that's specifically restricted to borrowing rather than inspection, and it relates only to solicitors and their clerks. There's no provision for inspection by any other person. Two things I'm going to mention by way of background rather than going into any depth in them. This issue was briefly considered by the Scottish Parliament in a petition in 2012. And there's some interesting material for those who want to go more into the background in the responses of the Scottish Courts and Tribunal Service and the Law Society. And the final piece of this background against which Cherry is decided is the decision of Lord Woolman in the BBC petitioner's case in 2012. And that relates to criminal proceedings in which the BBC sought access to photos which had featured in a murder trial as Crown productions. And they wished to use them for reporting on the convicted person's sentencing. And that involved consideration of copyright, ECHR issues, and the media's right of access to court documents, though for each of them, the treatment is relatively brief. Ultimately, the BBC was allowed access to those photos and was able to use them. But prior to Cherry, that's the only real consideration of this issue of access to court documents that I can find. Turning to Cherry itself. Almost all of you will, I'm sure, be aware that the main issue in Cherry was as to the Prime Minister's advice to prorogue Parliament. But what is interesting is there were two subsidiary issues, including the access to court documents issue by non-parties. And I want to look at how those are decided in light of the decision in in light of the decision in Cape, and what other questions are left open by that decision in Cherry. So what happens in Cherry is that three media organisations, the BBC, the Sun, and the Times, seek access to three separate categories of documents. And those are the pleadings, the written arguments of the parties, and four evidentiary documents, four productions that were put in by the Advocate General on behalf of the government memoranda, a handwritten note by the Prime Minister, and some cabinet minutes, all partly redacted. And the court does deal with this in its decision in Cherry. What I understand from speaking to some of those involved is that this was not able to be considered before the Outer House in the time that was available. And so the matter came to be decided on this access to documents points in the first instance by the Inner House. And I also understand it was opposed by the government, though I don't have much information about what the grounds of those opposition were. So the Inner House makes its decision in September 2019. And this is after Cape Intermediate obviously has been out there for a few months. What I want to acknowledge first of all is that Cherry was a decision reached under immense pressure of time, and that this question of access to court documents was very much a secondary issue. That said, I think it is useful to look at what was said about access to court documents and the court's reasoning and see what issues that throws up and what it might tell us about making such applications in the future. First of all, there is reference in the Cherry opinion to Cape Intermediate and to its emphasis on the principle of open justice. But the difficulty is that the paragraph in which that appears is ambiguous. That paragraph leaves it unclear as to whether the Inner House is adopting or endorsing or affirming, or whatever language you choose to adopt, taking on board the decision in Cape Intermediate, or whether it's merely referring to the fact that the media non-parties saw it as an important case. It's ambiguous. I think it would be hard to get away from the idea that the Inner House regards as important, but we don't have an unambiguous endorsement of Cape Intermediate and its importance in the context of Cherry. And then we come to the results for the parties, sorry, for the media parties here. And in respect of all three categories of documents, the media parties were granted access. But what is interesting is that there's different species of reasoning or at work for each category. In respect of the pleadings documents, if you remember the definition of writ under Rule 4.11 and that of any person having an interest, the court held that these documents were writs, the pleadings documents, and that it held, contrary to what is stated in the commentary, that the phrase any person having an interest was wide enough to encompass the media non-parties, so that those media non-parties could inspect writs under Rule 4.11. In respect of the other categories of documents, the position is much more unclear. They are not writs within the terms of that rule. And the court doesn't explicitly set out how it gets to its decision that these were documents that should be provided to the media non-parties. Now, in my reading, I think the only basis can be the court's inherent jurisdiction, which acts as a complement to whatever is available under Rule 4.11. So this seems to be the Inner House saying there is inherent jurisdiction of the Court of Session to order that non-parties be granted access to documents outside of those that are writs. But the court doesn't say so explicitly. The court also doesn't say anything about the test or the approach or the criteria that are going to be applied in determining when a non-party should be granted access. So that is left somewhat out there. We don't know what attitude a Scots court is going to take to a non-party who requests access. What are going to be the considerations it takes into account? Are some of the questions that arose in relation to settlement, in relation to standing or interest under the Cape Intermediate case, are those going to be relevant when a Scots court comes to consider the same issues? And just briefly, the court does note in one sentence that it would expect written arguments in reclaiming motions to be available to media parties under normal circumstances. I don't think that tells us very much, but it does suggest that there's at least one category of documents for one category of non-party where access has now become somewhat easier. I think in general, whatever Cherry does and does not say, it, like Cape Intermediate, perhaps signals a change in direction. I think it is possible to infer from the court's decision that going forwards, the court will take a more open and perhaps more permissive attitude to non-parties from a wider range of backgrounds, seeking to access a wider range of documents. And I think that will be a more favorable consideration given what the court is saying in Cherry. But again, it's a little difficult because the treatment of this issue in Cherry is quite restricted. And it does throw up a lot of questions. And it's to some of those questions and reflections on the wider issues that I now want to turn, bearing in mind the time that I have left to me. So I'm going to try and go through these in relatively brief form, but I think they are important. I've tried to divide them into two categories. What questions arise immediately from the decision, and what questions come up when we start thinking about access to court documents in a wider sense? I think the first question is in relation to the court's interpretation of Rule 4.11 and who that will apply to. The only cases we have on access to court documents at this stage are by media parties, Cherry and BBC petitioners. And in the grand scheme of things, media parties are low-hanging fruit. They are an easy person to say you have an interest for the purposes of Rule 4.11, or there is some interest in respect of the inherent jurisdiction. What will be more interesting is to see how that rule, or the inherent jurisdiction applies when you see someone with a different type of interest, such as the forum in the Cape case, or even a party seeking to use documents from one court proceeding in another piece of litigation, those offensive litigation purposes I outlined at the start. What will be the court's attitude to that? And will they be persons having an interest for the purposes of Rule 4.11? The next is kind of as to the scope and the existence of the court's inherent jurisdiction. I think implicitly the court is confirming that it does have this inherent jurisdiction, but again, the criteria on which it will exercise it are not clear. And this is going to be particularly important in the case of the Sheriff Court, because the terms of the Sheriff Court rules, the ordinary cause rules, are much narrower. The only thing you're going to be able to rely on in the Sheriff Court is the inherent jurisdiction. And so that is important, that the court can be seen as confirming its existence and how it might be applied. And the next point is where the court is asked to make a decision. As I said, what criteria will it apply? What tests will it apply? Should we regard the extensive discussions in each of the cases in Cape Intermediate as persuasive authority? But do we need to wait for them to be picked up and comprehensively affirmed by a Scots court? I think they provide a number of useful things to think about when you're trying to determine if a party should be granted access, but we don't have any explicit endorsement of that approach or those criteria as yet. There's also a technical procedural question. What is the route by which one makes an application as a non-party? I think it's probably under Chapter 15 of the rules, but it's not clear. And what we don't want is the court refusing these applications on a technical pleadings point. So I think we would benefit from knowing more clearly how these applications are supposed to be made to the court. And the last of these shorter questions arising out of Cherry is, what is the difference between inspection and copying? The rule says inspection, but in this case, copies of all the documents were provided to the parties electronically, it seems. In a case like Cape Intermediate, you're going to have a much larger volume of material. Is the court going to provide that to you, or are arrangements going to have to be made for copying, and what will those arrangements be? And that's not clear because the range of materials in Cherry was fairly narrow. And just very briefly, so I can get around to some questions, this whole question about access to court documents sets up a number of things. This is probably an area which is ripe for some form of legislative or rules reform because of all the uncertainties that seem to exist in this area. It's something where we might want to think about whether parties wish to go to arbitration or go to court, and it might be something that the open justice aspect of it tips the balance one way or the other to some degree. We need also to think about confidentiality within court proceedings or documents. And some of you will remember Lord Tyre's decision in Alliance Trust Savings, where he came down with a fairly stern warning about over-redaction of commercially confident materials. And the other is thinking about whether you need to take preemptive steps to protect yourself against access requests. So if a party is able to request something under Rule 4.11, do you need to think about how you can counter any possible requests? Is the court competent in its inherent jurisdiction to protect writs against disclosure under Rule 4.11? That might be something worth thinking about if you have a proceeding which is enormously commercially sensitive, and you don't want someone even looking at the pleadings. You need to think about then whether you can apply to the court to protect those, given the court's reading of 4.11 in Cherry. And the final point, very briefly, is what are the expenses consequences of this landscape? Should unsuccessful applicants to access court documents be paying expenses? Is there any scope to argue that they should have the benefit of protective orders in relation to expenses, as exists in some judicial review proceedings? I think the whole thing to take away from this is that I think the direction of the courts has changed, but there do remain a significant number of questions. This reading of the open justice principle allows for potentially, I think, more favorable treatment and greater access to court documents by a wider range of non-parties. But there's a lot that still needs to be worked through in either case law or in rules reform. And those are the questions that we're going to have to deal with from this point onwards. So on that note, I will try and take some of the questions that have picked up in the course of this talk. If there's anything that I don't get around to answering, then please feel free to contact me. My details are on that final slide.
Fergus, it's Andrew here. I don't see any questions arriving just now. That may be a technical issue, but it may be that people are just shy at these types of things. But from the looks of it, Jonathan seems to have a virtual hand up. So.
A virtual hand up. Shy or needing to get on to something else. Both are possible. Thank you very much, Fergus. This is, I suppose, more an observation, really, rather than anything else. Can I talk about such cases as have been reported in session cases? Because we have an international attendee, I'll just explain that's our top level of reporting. And the Advocates Library holds the session papers. Now, those papers will include pleadings, more recently notes of argument, and sometimes a selection of productions. And they're bound into volumes and they're held in the Advocates Library. And they're a very useful tool if in trying to discern a leading authority's real ratio. They can be a very useful resource in working out what really was being said by that case from 1870s and the Glasgow banking collapse, for example. Now, what went through my mind was this. Such storage, such archiving of material might be said to be a matter of something that's practical. I mean, it's not the substantive law, it's not procedural law. But in a sense, if the case is old enough to have been reported, at least some aspect of open justice has already been conceded, perhaps.
It's an interesting one. And I think what we're talking about here, I think, is a relatively short period of time. I think the rules generally say that court papers will remain with the court for 5 years after a final stopping point before they're then transferred to the national records. And the session cases and the session papers are obviously a resource that's available in some cases. But as you say, they don't include everything that might have made its way onto the file. They won't include things like transcripts and things like that. And CAPE is unusual because it does involve a party moving very, very quickly after a case is concluded to secure access. And one of the things I didn't talk about is that there's actually an urgent ex parte application in the High Court to secure copies of those documents in the court to stop the parties taking them away and disposing of them after settlement. So there are all kinds of interesting questions around that. What I think isn't clear is the session cases are obviously a useful resource, but if you wanted to go deeper, you have to do it quite quickly. And what is going to be the approach that the court is going to take to that? How do you do it? It's just not very clear at this stage. And that's kind of one of the things I hinted at, that some degree of consideration by, say, the Civil Justice Council may be worthwhile in this area. As far as I'm aware, it's not an issue that either the Law Commission or the Justice Council has looked at to date.
I see we have a question from Charlotte Edgar there. Can you see that, Fergus?
I can, yes. So the one thing I might mention in response to Charlotte's question is...
Perhaps read the question first.
Yes, sorry. Is there any guidance from the case law on these issues from other common law jurisdictions? For example, New Zealand, Australia, and Canada. One thing I was thinking about, and I'll probably mention it, I should say this is probably going to be the subject of an article, which I'm in the process of writing. So if anyone has any further input on that, they're welcome to contact me. One thing is the senior courts in New Zealand, both the High Court sitting in its criminal jurisdiction and in its civil jurisdiction, use a common set of rules for access to court documents. And they have a procedural setup. That is quite interesting because it draws a distinction between cases that have gone to a hearing, cases that haven't. And that's one of the points that's touched on in CAPE Intermediate. And I think is quite important in most people's conceptions of this. Should you have access to witness statements, for instance, where those haven't been tested in the course of a trial? A lot of people, I think, would say no, because those witness statements might not stand, or they might not actually be the truth once they're tested in cross-examination. So that's one of the important points that those rules deal with, is the distinction between documents that are in existence prior to a hearing and what value can be attributed to them, and documents post-hearing. And I think that's one of the things that any rule will have to deal with. And the New Zealand approach is to take a quite narrow approach to documents prior to trial, and then quite a broad approach after these matters have been heard in court. I don't know if that helps too much in terms of your question, Charlotte, but there is some guidance in that respect. And what I should also say is there's quite a lot of material in the English cases. And as I said, that's likely to be regarded as persuasive authority in some respects, but we are dealing with different rules and some features of the Scottish court system which don't map to the way that the English courts handle documents, for instance.
I don't know if there are any other questions, perhaps.
From the chat or elsewhere, that may very well be, Fergus, because you have answered everything absolutely, or dealt with everything completely comprehensively in the course of your talk.
I should say for everyone, if you have experience of trying to get access to court documents on behalf of non-parties, I'd be fascinated to hear about it. I've tried to do it in respect to some English cases once upon a time, but I've not had any experience trying to do it here, and I don't know what people's experience of it has been when they have tried. The materials covered in the 2012 petition suggest that it can be quite difficult to get access, and that the Scots Courts and Tribunals Service, at that point in time at least, took a fairly narrow and restrictive approach to applications by non-parties.
If it does become a matter for reform, for example, on the part of the Rules Committee, events such as this, thoughts that are raised here, suggestions, can all become part of the material that is drawn upon for a subsequent properly worked out set of rules. So this may be the start of a discussion that find no doubt in something like 10 or 15 years time.
Or a number of applications just annoying the courts and trying to get access to things because people are noisy. But yes, one of the two.
Indeed, I think that is what, at least for my part, I found stimulating about this talk, Fergus, because one, it points to the fact that there may be potential assistance for one's own case from other cases, whether it simply be the pleadings or notes of argument or actually productions. And the other thought is, if this is potentially a source of assistance, how do we go about it? Mm-hmm. So I have found it stimulating, and I'm very grateful to you for your talk today, and I'm very grateful to everybody who has attended. I do think it points or bodes well for us trying to restart the economy, that people in these very strange times are thinking about things and prepared to come to this. Andrew, I don't know if you want to wind up, because as I said at the beginning, we have 4 further members of the stable joining us, and on each of the next 4 Wednesdays, yes, I suppose that works. There are similar talks. I think most of the places are taken, but Andrew, I hand over to you.
They are indeed. I'm delighted that the response to the other talks has been such that they're all now sold out, and that, as I mentioned earlier, has prompted us to arrange to upload our various talks. Once they've been concluded and once they're available to us, they will be uploaded to the new Arnot Manderson YouTube channel. Which again is a sentence I just didn't think I would ever find myself saying, even at the start of this year. But we will have a YouTube channel, and each of these talks, including Fergus's, will be available to you. Thank you to all the delegates. It's encouraging to see so many names that I do know, but also to see so many people that are unfamiliar to us. I think that's it's lovely for you to have joined us. And remember, the option is there to email us anything via the clerks if you're interested at all in conversing with Fergus about what he's spoken about today, or indeed if you would like to instruct Fergus, which is, I suppose, one of the very the main points of these types of seminars. If you find that you would like to mark his diary, we have access to Fergus's diary, and we'd be delighted to take instruction for him or any of the other devils that are either with us or joining us shortly. So with that, I think I will just conclude and thank you all once again on behalf of Fergus, Jonathan, and everyone in the stable.